Hi everyone and welcome back to another video. Now, 5 members of the climate change group Just Stop Oil have been sentenced to up to 5 years in prison after being convicted of conspiracy to cause a public nuisance following a trial. Now in this video I'm going to briefly explain the facts of this case, and then I'm going to go through the judge's sentencing remarks to explain how he came to the sentence he did, and then I'll go through whether or not this is likely to be successfully appealed. Now, the sentence awarded is sure to ignite a debate between whether this is the stifling of the right to protest an important issue such as climate change, or whether this is an appropriate response to attempts to cause major disruption to the UK infrastructure. Welcome to my channel, Andy on Crime, where I talk about high-profile criminal cases and other aspects of criminal law in England and Wales. With all that being said, let's get into the video. I'll start briefly by just talking about the facts behind this case. 5 individuals were charged with the criminal offence of conspiracy to cause a public nuisance. Now, the actual offence of causing a public nuisance is a relatively new criminal offence and is contrary to Section 78 of the Police Crime Sentencing and Courts Act of 2022. Now, the individuals who were charged were Roger Hallam, Daniel Shaw, Louise Lancaster, Lucia, Whittaker, Abreu and Cressida, Gethin. All 5 were members of Just Stop Oil, who have become synonymous with disruptive protests, including blocking roads and interrupting football matches, all with the aim of promoting their climate change message and attempting to change government policy. The specifics of the offending that they were charged with was that they were involved in a conspiracy to disrupt traffic on the M25 motorway by having protesters climb onto the gantries which are erected over the motorway. This would cause gridlock as motorists would not be allowed to pass through with protesters attached to the gantries. At their trial, the key piece of evidence against the group was an audio and video recording of a Zoom meeting on the 2nd of November 2022, which was recorded by an undercover journalist from the Sun newspaper, which was later forwarded to the police. And this meeting over Zoom was to arrange protests which were to lead to significant disruption. Now, the judge outlined the specific contributions of each of the members of the group at page 16 of his sentencing remarks. Roger Hallam was found to have given a lengthy pep talk explaining why the protests were necessary and justified. Daniel Shaw chaired the meeting and was intimately involved in organising recruitment and the training of protesters, and the other 3 had a role in inspiring other would-be climbers based on their own experience. And the judge outlined that as a result of the group's actions, 45 protesters climbed or attempted to climb up gantries on the M25 between the 7th and 10th of November 2022, causing disruption estimated at over £750,000 in economic costs, as well as significant impacts on members of the public, as outlined at paragraph 7 of the sentencing remarks. On the 18th of July 2024, Roger Hallam was sentenced to 5 years imprisonment, and the others were all sentenced to 4 years imprisonment. And I'm going to talk about the sentencing remarks, and I've put a link in the description of the judge's sentencing remarks, and I would encourage anyone who is interested to read through them. They're about 23 pages long, but throughout this section of the video I'll post specific paragraphs on the screen from that judgment. So the first thing to say in this case is that there are no definitive sentencing guidelines for the offence of conspiracy to cause a public nuisance. This is due to it being a new offence, which I mentioned at the start of the video. Now, most criminal offences have a defined starting point and a range for different levels of offending within that specific criminal offence. But where this is not the case, where there are no definitive sentencing guidelines, the judge will tend to look at case law to find an appropriate level for where that offending fits into. And in this case, as outlined at paragraph 23, the judge referred to the case of the Crown and Troland and Decker from 2023. This is where the Court of Appeal confirmed that a sentence of 3 years and 2 years 9 months imprisonment was not manifestly excessive for individuals following a conviction for causing a public nuisance in relation to disruptive protest, much in the similar way as was being planned in this conspiracy. Now, the judge in this case found that the position of the defendants was far more serious, as they were going beyond a single act of protest. And at paragraph 33, the judge outlined that there were 6 aggravating factors in this case. These are factors which increases the seriousness of the offence and pushes the starting point for the offence upwards. And you can see on screen that some of the factors that he found included the very high level of disruption caused to the public, and that each of the group had previously been convicted of 1 or more offences in relation to direct action protest. At paragraphs 34 to 36, the judge talks about the considerations with respect to the aims of the group, given that the conspiracy was an act of protest in relation to climate change, and there could have been some leniency offered as a result of the aims of the group. However, he concluded that this was not appropriate, given the extreme and disproportionate level of disruption that was planned. Now, the judge at paragraph 43 talked about the attitude of the defendants towards the rule of law during their trial. And though he states at paragraph 44 he is only sentencing them for the conspiracy in 2022, it would go to factors of mitigation, where he would find that there was less mitigation given their attitudes involved in the case. Now, in respect of the individual members of the group, he gave the following remarks. So for Roger Hallam, he stated he had a substantial criminal record for offences committed in the context of direct action protest. He was deemed to be in the most serious position of all the defendants, as he sat at the highest level of the conspiracy. And Roger Hallam was also under a suspended sentence for a previous offence. Daniel Shaw was described as being up to your neck in the organisation of this conspiracy, and he hoped that there would be massive disruption. Lucia Whittaker de Abreu had 3 previous convictions for offences of obstruction during direct action protest. Louise Lancaster had 6 previous convictions and was also under a suspended sentence. And Cressida Gethin had 3 previous convictions, and she again was under a suspended sentence order. So in conclusion, the judge felt that Roger Hallam's conduct called for a longer sentence than the others, and he was sentenced to 5 years imprisonment. For the other 4, the judge stated there were no grounds for differentiating between them in terms of the sentence that he would award, and he sentenced them all to 4 years imprisonment. Now, all of the individuals will serve half of their sentence before they are automatically released, and this is standard as in most criminal sentences. Now, there is talk of the current government reducing that to 40% of their sentence in order to ease overcrowding in prisons, but that's not yet in law, so at the moment they will be released at the halfway point. Now, all 5 individuals can appeal their sentence if they so choose. The test for the Court of Appeal, which is the court that they would apply to appeal their sentence to, the test for them is to consider whether or not the sentences are manifestly excessive. Now, sentencing is an art rather than a science, and 2 judges might come to 2 different conclusions as to where a sentence sits. That doesn't mean that either of them are wrong because it sits within a range. As long as a judge doesn't go outside of that range, either left of arc or right of arc, then it will not be considered manifestly excessive, even if the sentence seems harsh. And in my opinion, given that the Court of Appeal determined that 3 years was appropriate for committing the offence of causing a public nuisance for this type of behaviour, they are unlikely to find that a sentence of 4 or 5 years is manifestly excessive, given the nature of the conspiracy that the judge found. So to summarise, the judge found that this was a very high level of disruption that was to be caused. The group had previous convictions. The relevant case law for offending of a lesser nature determined that 3 years was not manifestly excessive. The judge found that there was little mitigation for the defendants, and the appropriate sentence was 5 years for Roger Hallam and 4 years for the others. What do you think about the sentences imposed in this case? Are they too harsh, or is it justified because of the disruption that they were attempting to cause? Let me know in the comments down below. That's all for this video. If you did enjoy this video, then please do give it a like. And if you'd like to see more from me, then please do subscribe to my channel. Thanks for watching. Take care.